Welcome to On the Ballot with Ballotpedia, where we connect people to politics by providing neutral, nonpartisan, and reliable information on our government, how it works, and where it's headed.
Hello, everyone, and welcome to another episode of On the Ballot. I'm your host, Norman Leahy. I'm a senior editor here at Ballotpedia, and one of the things that Ballotpedia tries to do as much as possible is cover what's going on in the federal court system. And of course, the biggest cog in that system is the U.S. Supreme Court, which starts up its new term in this coming October. Joining us to talk about some of the big cases the court will hear and might hear is Zachary Shemtob, who's the executive editor of SCOTUSblog. Zach, welcome back to the show. Appreciate this.
Very glad to be here.
All right. There's a lot going on, a lot of moving parts in this upcoming court session. So what do you think are maybe the top 4 or 5 cases that we should be watching?
So I'd say, just to give a little background, so the court at this point has decided to hear a little over 30 cases during the term. We're not counting those cases on the so-called emergency docket. That's a separate thing, and I don't know if we have time, but I'm always happy to discuss that since that takes up so much oxygen. But these are what are called the merits cases. So beginning on October 6th, as you said, the court will start hearing oral argument on these merits cases. These are decided with full briefing, oral argument, and then you have formal written opinions and decisions, unlike the emergency docket. So among the merits docket cases that I'd say are the biggest, to go back to your question, the tariffs case has to be number one at this point. Then I'd say probably the Louisiana voting case. Then you have the transgender cases, transgender and sports cases. Then you have the possibility of some emergency docket cases then going on the merits docket. And that we think about the FTC case and possibly the Fed case with Lisa Cook. And so I'd say those are the current biggest ones, but there's a number of other important cases, including on campaign finance reform, a death penalty case, etc. So there's a whole lot to discuss, but I'd say those are, for now, the big 5.
Yeah, and it's almost impossible to say where to begin and do things justice, so to speak. But let's start with the tariffs case, because I agree that that's important because there's actually money at stake in this, lots of it. So can you give us the thumbnail on that one?
Absolutely. So the tariffs case actually consists of 2 cases, and actually there were also, to be super technical about it, there are 2 types of tariffs, or if not more, that Trump instituted. But this is looking at all those tariffs, and he instituted these through what's known as IEEPA, or the International Emergency Economic Powers Act. I think I got that right. And this allows the president, according to Trump, to levy tariffs on nearly all goods imported into the United States through a series of executive orders. And so when Trump imposed the tariffs, he relied specifically on a provision in IEEPA, and this authorizes the president, and I'll read this off, in times of national emergencies to, and this is from the text, to regulate importation of property. It's regulate ... importation of property in which any foreign country or a national thereof has any interest. And so Trump used that language to say he has the authority to impose these massive sweeping tariffs.
Right, and adjust them, it seems like whenever the mood strikes. So, but who brought this case?
So this was brought by two separate cases brought by small businesses.
Okay.
Separate small businesses. And these small businesses contend that the tariffs are costing them massive amounts of money. And one is at least claiming that this could put them out of business entirely, I believe, or at least have severe repercussions on their business. And so they brought this case forward. A district court, there were 2 district courts, but district courts ruled that the tariffs were illegal. Then the kind of lead case, although again, there are 2 cases, but one of the cases went to the U.S. Court of Appeals for the Federal Circuit, and they voted 7-4. So it was actually closer than one might think based on, I know there's a lot of media reporting saying, oh, these tariffs are outrageous. They're clearly unconstitutional, clearly illegal, improper, but it was a little closer than one might think in the circuit court. And so it was 7-4, and they struck the tariffs, but they kept them in place for now for the Supreme Court to decide. And now it's up to the Supreme Court, which will hear oral arguments in November 5th.
And
They
yeah, and to be clear, we're only talking about one flavor of tariffs that the administration has at its disposal. So it's not everything, but it's one of the key elements of the tariff
exactly.
policy.
And there's also claims by the Treasury Secretary, Scott Bessent, that, these can be imposed certain economic, there are ways to impose similar economic means through other mechanisms. So
Okay.
this wouldn't necessarily be the end of these kinds of economic, uh, kind of economic issues, but it would take something major off the table for the Trump administration.
And let's move on to another one that I think is very important is the Voting Rights Act case out of Louisiana. Can you explain that one for us?
Yeah, so this is Louisiana versus Calais, although no one knows how to pronounce that.
Yeah.
I think even the justices had pronounced it differently.
Okay.
Here, a group of Louisiana voters who describe themselves as non-African American have argued that a congressional map, which created a majority black district in the state, was an unconstitutional racial gerrymander. So it was created in accordance with Section 2 of the Voting Rights Act, which is to prohibit election practices that result in a denial or abridgment of the right to vote. But these folks are claiming that actually that is directly contrary to the 14th Amendment, which bars the federal government and states from denying or abridging the right to vote on account of race, color, or previous condition of servitude. So it's a very complicated case, but that's the gist of it.
But this is not going to be the first time the Supreme Court has addressed portions of the Voting Rights Act. Is that correct?
Yeah, I mean, it's Shelby County, which again gets to the formula to determine certain pre-clearance for states, or the ability of states to draw, certain things in accordance with race. They said that was ultimately improper and unconstitutional. So this is another look at the Voting Rights Act, and this is Section 2.
And this all fits within the political context of states that are considering or actually have done redistricting of the congressional districts before the midterm elections. So it takes place within that context. So it's as much as the court may want to be above a politics, it often runs alongside it. So
Correct. That's fair to say. And what's also kind of interesting is originally this case was set to be decided last term. The last day of last term, the court announced that it would be reset to this term. Justice Thomas dissented and said he would decide on it right now. But clearly there was some disagreement, or at least a need for more information on the court. They weren't ready to decide it last time around, so they kicked it over to this term.
So those are at least the two that I agree with you. Those are the two big ones. What do you think falls into the third slot, in your opinion?
I mean, the court, I don't love this term, but the court is re-entering the so-called culture wars in the, transgender cases. One of them is West Virginia versus BPJ. And in this case, the court's going to hear it was filed by a 14-year-old transgender student who began to receive puberty blockers and hormone therapy. And that student is seeking to compete on the girls' sports team at middle school. And there is a law in place in West Virginia saying that the transgender student cannot do so. And so the challenge here is that law violates Title IX, which is a federal law prohibiting sex discrimination in educational programs, and also violates the 14th Amendment because it's, basing this on account of the person's sex, and therefore that's unconstitutional.
Right. So those wars keep getting litigated, it seems. Now, you have talked about other criminal cases that are coming up, mentioning a death penalty case.
Yeah, one of the more interesting ones is Ham versus Smith. And this case, again, it's complicated as death penalty cases always are, but it deals with IQ tests. And so there's a case called Atkins. And in this case, Atkins decided many years ago, a 6-3 majority ruled that the Eighth Amendment's prohibition of cruel and unusual punishment forbids the execution of someone who is mentally disabled. And they said in the opinion, I believe it was in a footnote, that, well, how do you measure whether someone is mentally disabled? And they referred to IQ test, and they said something like an IQ of approximately 70 or lower. And so in this case, this individual who's on death row took multiple IQ tests. Some of them were above 70. But if you combined all the tests, the standard range of error, the person's IQ could have been as low as 69. And so the circuit court said, well, in accordance with Atkins, that could be problematic because you could be executing someone whose IQ is mentally disabled. And the court is looking at this case. They're saying, well, did they base it on one IQ test, multiple IQ tests, or kind of a holistic range of things? And so I think the court is, and I could be entirely wrong on this, but I think the court is going to shift from a line of, okay, well, if it's under 70, then you can't be executed, to, well, let's not only look at IQ tests, but let's potentially look at all these different factors, reports, expert evidence, etc. And so that could change the parameters of when someone can be subject to capital punishment.
And you mentioned an FTC case, a Federal Trade
Yes.
Commission case.
So this was on the emergency docket, as there's so many things. And in this case, Rebecca Slaughter, who was on the FTC commissioner, was fired by the Trump administration without cause. And according to, the statute that governs the FTC, you can only fire someone for cause, but Trump did not do so. And so the challenger here, Slaughter, is contending that was improper for the Trump administration to do. The Trump administration is saying, no, this handicaps our ability to control the executive branch, which goes to, this is the larger issue, but unitary executive theory at the end of the day. And the tricky thing for the Trump administration is precedent is technically on Slaughter's side, in that there's a case called Humphreys, Executor versus United States, decided decades and decades ago, almost a century ago. And in Humphreys Executor, they said that, the president, it's clearly FTC commissioner, so it was talking about the FTC, which is in play here, can only be removed for cause. And so that would seem to fly in the face of what the Trump administration did. The Trump administration's argument in response is that over the years, the court has watered down Humphreys Executor because they made the executive more powerful. And additionally, the FTC as it currently exists is a completely different beast than it was at the time of Humphreys Executor. At the time of Humphreys Executor, they say it was much more muted. It wasn't nearly as powerful. It didn't have as much authority. So that's now entirely different at this point. And the president needs to therefore be able to control this, essentially this beast.
Okay.
Yeah.
But that segues us to a case that the court may hear. And of course, it's always dangerous to speculate on what the court decides to hear. But this one's kind of important, and it involves the Federal Reserve Board governor. Can you give us a quick one on that one?
Yeah, so this deals with Lisa Cook. Lisa Cook is, as you said, a governor on the Federal Reserve. She was Democratic appointed through Biden. The Trump administration fired her, this time claiming, unlike in the FTC case, that it was for cause. Their argument was that she committed mortgage fraud. Whether she committed mortgage fraud or not is now kind of unclear on how you weigh mortgage fraud, etc. But regardless, they attempted to fire her. And she has pushed back and argued that a number of things, but one of them is that she wasn't, didn't qualify as for cause. And two, she has a Fifth Amendment property right. So she was entitled to some sort of hearing before she was fired, which the administration never gave her.
And this also leads us to this broader idea of the emergency docket, which, as you said, is getting a lot of attention, more than I ever remember. And maybe I'm misremembering. Lord knows I can do that. But it seems like this has only become a thing of can you explain in layman's terms what this thing is, why it's such a big deal right now, and how it is influencing or not what the court does on the merits docket?
I'll try.
Okay.
Yeah, yeah. As you said, this has only become a bigger deal since 2014 when these emergency applications became more popular. But let me back it up. So emergency applications typically are when, let's just talk about the administration. So the administration, let's say the Trump administration, a lower court judge, a district judge decides a case against them. And the Trump administration says, this is incredibly important. This needs to be resolved right now. What they've done is completely upended everything we're trying to do. And so they file an emergency application, sometimes after, sometimes before the circuit court has decided, which typically reviews the district courts. And they go to the Supreme Court with this emergency application, and they say, you need to stay the district court's decision. And these cases, since there's not a lot of time, there isn't as much briefing as you have in the merits cases, and there's typically not oral arguments either. So all you have is, in this case, the Trump administration saying you need to block the district court ruling, and the other side saying, no, you don't. And the court hears it on a very or a somewhat expedited schedule. These can take a little while to decide still. And then they issue an order as opposed to an opinion. So in the merits docket, you have these reasoned opinions. On the emergency docket, you have very short orders. They can be like 4 sentences, and sometimes you have concurrences and dissents. And so when we talk about the emergency docket, we talk about emergency applications that can go anytime and do go anytime to the Supreme Court, which are then quickly decided by that court. And I know I'm being long-winded here, but yet they're not merits cases. One, because they're not decided on full briefing and oral arguments. But two, because they are, at the end of the day, they're not permanently deciding the issue. They're just deciding whether to stay or stop the district court. And then the actual substance of the issue will be litigated below before potentially coming again to the Supreme Court on the merits. So,
Right. So
I know that's a lot.
Well, I guess to put it another way, they're not. They have effects, but they're not definitive.
Correct. They're not definitive. The complication is part of the standard in deciding whether to lift a stay. You have to decide a little on, do you think that this is meritorious? And so they're hinting at how they may ultimately decide on the merits on the emergency docket.
And I understand, too, from reports that there's a little bit of static between the various levels in the federal court now. Some judges at lower courts saying, we'd really like to do what the court has ordered, but you're writing haiku, and we don't quite know what the meaning is. I don't recall stuff like this occurring before. What are we to make of all of that?
I mean, it's definitely a growth in so there have always been an emergency docket in terms of things like death penalty cases.
Sure.
So death penalty cases, before someone's executed, they have a last minute application often to the Supreme Court. And the Supreme Court almost always denies it. But that was kind of what much of the emergency docket consisted of. In the last few years, we've seen a much more active executive branch trying to utilize this mechanism, which was always technically there, in order to stop lower courts from interfering what it sees as its prerogative. So there's a lot of theories why this has come about, but I think that's a major one. And this was utilized, by the way, by the Biden administration as well. This was not just the Trump administration. But I think part of it is a more active executive branch, which is willing to get involved with judicial decisions.
Okay, fine. That's great, and I appreciate you indulging me as we went down that path. Um, I want to think of a couple more cases that you, looking over the horizon, they may not be on the Supreme Court's merits docket right now, but what are a one or two others that you think that we should be watching for that could be?
So I don't want to sound sensationalistic, but I will put this one out there because it got a lot of media attention. So it's whether Obergefell will be overturned. So Kim Davis, who was the clerk who became famous for refusing gay marriage licenses, she went through a number of court proceedings and then was eventually fined, went before a jury because she refused to confer these marriages license, which was unconstitutional. And she was fined by a couple $50,000 a piece. So I think $100,000. She's challenging that decision, and now it's been brought up to the Supreme Court. And there's a number of more technical issues there, but one of the issues she's raising is that Obergefell was unconstitutional in the first place because she said it leaves her with a choice between her religious beliefs and her job. So after this, and what's kind of interesting, this is what SCOTUSblog reported on. Normally, so when she issued this, the other side waived a response, which is showing that, we don't think your petition is credible. We don't think this will be granted by the court. We're not even going to bother to spend money and resources answering. And the court actually issued an order saying we would like a response. So yeah, that generally means that one justice, all you need is one justice for that. But it shows that at least one justice is interested in thinking more about this issue. Okay. And so I think that indicates there is some interest. I mean, my guess is Thomas and Alito would be genuinely interested in revisiting Obergefell. I'm not convinced that the rest of the court would. But again, this is, now something that's being considered for cert or being considered to be heard by the court. Although I am ultimately skeptical that they will agree to do so.
Yeah. And gosh, there's like we opened the show, there's a lot of stuff that is still potential to go before the Supreme Court. And it does seem like each new session, there are monumental issues before the court. And this one will not disappoint. And for our listeners out there, you can learn more about the upcoming SCOTUS term in the links below. And we'll be back soon with another episode of On the Ballot. And we thank you for listening. Zachary Shemtob, the executive editor of SCOTUSblog. Thanks for joining us. And by the way, if you haven't bookmarked that website, SCOTUSblog, do read it. You will know everything you need to know about the Supreme Court. Zach, thanks for joining us.
Thank you.
And we'll be back. And until then, I'm Norm Leahy. We'll see you in the digital pages of Ballotpedia. Take care.